Okay. We are going to, over this next hour, we are going to feed back to you what you have been discussing in the two roundtable discussions, and then that having been done, engage in a Q&A session. So the floor will essentially be yours. But before we start that, there were a number of questions have come up from tables, and there was some reference during the advocacy group sessions about the European Court of Human Rights. And Dr. Emer Brown, I omitted to tell you all that in addition to running marathons, she's a doctor as well. Emer is going to talk a little bit about, give a perspective, an update on some of the issues that people have been raising about this matter. Emer.
Here. Okay, everyone. A few people on various tables asked us questions relating to the European Convention on Human Rights, not surprisingly because some of the speakers raised it. So some of you may know all about it, some of you may have a vague idea about it. So for the people who know all about it, excuse me while I give everyone else a bit of an explanation of it. You'll have heard Mr. Hagan and Mr. O'Hare both referred to a particular judgment of the Court of Human Rights. It's called Schalk and Kopf against Austria. It's in one of the footnotes, I think, on about page 3 or so of my paper, and I think it's referred to elsewhere. Just so you know, the European Convention on Human Rights is an international treaty. Now, it's not part of the European Union. It's an entirely separate system to the European Union. It's a separate international treaty that focuses solely on human rights. It came about in the aftermath of World War II, and basically its aim is to set a minimum standard, so a baseline, lowest common denominator standard in respect of various fundamental human rights across Europe. There are 47 contracting parties at the minute. So that's really what the convention is. The convention has its own court, and if you ratify the convention, which we did early on, I think it was either us or Sweden who was first, so that was nice. We won at something. So we don't often win in the soccer, etc. is all I'm saying. We ratified it some time ago. It's been enforced since 1953. Under the convention, if you've ratified it, you accept the right of individual petition, which means that if somebody is in the state that's ratified the convention and they feel their convention rights have been violated in some way, they have a right to make an application to the Court of Human Rights. Now, it's not an appeal the way you'd appeal within the Irish legal system. It's a separate application to this international court, and the international court assesses whether or not they think your convention rights, the standards of which they interpret, have been breached or not. And that's really how it works. There are various rights under the convention. Some of them are absolute, like the right to freedom from torture. Most of them aren't absolute. So rights such as the right to family life isn't absolute. It's an important right, but it's not absolute. The right to marry is an important right, but again, not completely absolute. Like you wouldn't have the right to say you have the right to marry your brother or sister or something like that. That would be an absolute right. So in areas where the right isn't absolute, there's a thing called the margin of appreciation that some of you have mentioned at various tables. The margin of appreciation is kind of a room for manoeuvre that the Court of Human Rights accords the state in certain areas. So particularly if it's an area that involves some assessment of religious sensitivities or moral sensitivities, the Court of Human Rights will give a broader room to manoeuvre to the state, and they'll be less likely to find that some decision by the state is in breach of the convention. That's what that kind of means. Now, just the case that was mentioned by the two speakers, one on either side, this Austrian case, both of them described it completely accurately. They both had very good descriptions of it. They both obviously focused on slightly different elements of it, but both descriptions were completely accurate. That was a case in which a same-sex couple argued that they had the right to marry, or they ought to have the right to marry under Austrian law. The Court of Human Rights in that case said that as a same-sex couple, they had the right to family life. Now, that in itself was actually quite a significant step, because before that, the Court of Human Rights hadn't actually recognised that same-sex couples fell within the definition of family life. They'd said that unmarried straight couples did, or parents and children did, siblings, etc., regardless of marital status. But they hadn't taken that step for same-sex couples until this Austrian case. So they kind of won on their Article 8 right to family life point. The court then went on to look at Article 12. Article 12 of the Convention sets out that men and women of marriageable age have the right to marry. Now, the court has traditionally interpreted that in a specific, quite literal way, i.e. they view that as men and women have the right to marry one another, not men have the right to marry men, women have the right to marry women, or anything like that. They've interpreted it quite literally. So their position on Article 12 at the moment is that there is no convention obligation on the states, including Ireland, to legislate for same-sex marriage. There's no obligation, but neither is there any impediment in the convention to taking that kind of a step. There's no impediment whatsoever. Bearing in mind as well that this is a kind of a definition of a family it can be somewhat societally dependent. So depending on where you are, you might have a different view of what it is. So that's really their position on that particular area. Now, just to warn you, in case in 3 years' time you pick up a paper and it says Court of Human Rights legalises same-sex marriage, the Court of Human Rights does sometimes evolve its position over time. And when I say evolve its position, I mean sometimes they change their mind depending on developments in social attitudes, etc. I use the word evolve its position because I got told off for saying that they changed their mind by a former judge of the Court of Human Rights. They have evolved their position in various areas. For example, the rights in relation to the rights of transsexuals. They're now more open to recognising various rights of transsexual people, including the right to have their birth or have some notification on their birth certificate setting out their acquired gender and their right to marry in their new gender, for example. Equally, with issues such as same-sex adoption, they used to leave that entirely within the margin of appreciation of the member states, and nowadays they seem more inclined to intervene if it appears that there is discrimination in the differentiation between same-sex adoption and opposite-sex adoption. So I hope that helps. I was asked about it a few times, so I thought it might be useful for everyone.
Okay. Thank you very much, Emer. I think that was very, very clear, or as clear as that could be made. Now, we are now going on to, in a sense, feed back to you what you've been saying. And David is going to take us through that.
Thanks, Tom. So just to reiterate what we've talked about in previous weeks, we've done our best as a group to come up with some bullet points that tries to summarise the discussions you've had throughout the course of today, but there's huge warning notes to be attached to this. Because obviously we've had to do this at great speed. So I just want to stress again that we have very good notes from each table that's been taken throughout the course of today, and it's those notes that are reflected in the final document that's produced. So don't read too much into the bullet points. It's just an attempt to try and get the discussion going. So if we start with the first bullet point, points in favour of I better put this up myself, otherwise I'm not going to be able to read it. Points in favour of reform, excuse me. Sorry. So, points in favour of reform. If we're going to address anti-discrimination in society, we need to be proactive. It needs action. It's not something we can just sit back on. That seems to be that first point. A lot of these are going to be very related, as you might expect. We need to protect children from homophobic bullying. That was a point that I think came up quite early this morning. Children need equality regardless of the sexual orientation of the parents or the nature of their relationship. Society is evolving, so it needs to move with the time. And for example, one table made this point, it was once believed that lone parents were inadequate as parents. Society has moved on from that, and it's now generally accepted that lone parents can be just as adequate as where there are two parents involved. Marriage should be inclusive. It's about love. The issue is a human rights issue, and therefore we need to show tolerance and respect. And a point that came out this afternoon from one of the tables, tradition does not outweigh equality. So these seem to reflect a lot of the issues that we were getting from the summary notes in our quick run through on points in favour of change. And then points in favour of the status quo. We don't know enough yet, so we should move more slowly, and perhaps a legislative approach would be better than constitutional reform. Oh, I beg your pardon. Thank you. Okay, we'll try again. There we go. Points for status quo. We don't know enough yet, so we should move more slowly. Legislative approach would be better than a constitutional reform. To make this step is redefining marriage, which is obviously a very fundamental step, is a point that came up from some tables. A mother and a father is a natural position for children. A purpose of marriage is to produce children, and that should be reflected in the current status quo. Is society ready? This is a counterpoint to what we saw on the previous slide. Is society ready for this change? And then there's a bit of overlap here. Unforeseen future consequences. If we make this change, well, what other things flow from that we're not necessarily going to be able to perceive? So that sort of gets into the issue about there being a creep effect. If we make this change, then this inevitably leads to other changes which we may not really want to be considering at this point. And then there are consequences for freedom of conscience for teachers and parents. And then a third slide, a final slide. So options for reform. This is starting to try and get to grips with some of the things that the convention may want to be considering in discussions for tomorrow, perhaps. So what came out strongly from a number of the tables, well, by no means all, but certainly quite a proportion of the tables, was this sense of full equal marriage rights was favoured, in specifically that the Oireachtas should be directed through constitutional change to make this change. That an option for reform, that the Constitution should define what it means by the family, and it should do so in a very inclusive way. That parents should be treated equally regardless of the nature of the parent or the context of the parent, that all parents should be treated equally. That inheritance and property rights should be addressed, and surrogacy issues should be addressed. And then sort of two points that have a relationship clearly: protecting the rights of religious groups, so allowing the churches the right themselves on this issue, and particularly rejecting the right of faith schools, that those should be protected. So that's, as I stress, with all the warning notes attached to it, is an attempt to try and come up with some sort of summary to guide the discussion for the next while.
Okay, we have effectively 45 minutes for this discussion. And how I would propose we manage that is that we might go put back up these slides again, and we give 10 minutes to each of the three slides, and then we have 15 minutes left, if you like, for anything. What I would like to do is invite comment from the floor, and if there are any questions in particular, given the fact that we still have our excellent experts, if there are any further questions anyone has, that would be fine as well. So if we could put up the first slide, and I am conscious that there are people this morning who tried to get in and I couldn't allow them in for lack of time, so if some of those want to indicate they want to speak, I'd be happy to do so, take them. But, okay, so the first slide up there, comments on that first slide. Okay.
Chairman, just a point on the heading, points in favour of reform. I think the vast majority, if not everybody, would be in favour of reform. But the issue is, are we in favour of constitutional change? Thank you.
Okay. Thank you. Any other comments? This is surprising. But, Stephen, and then we'll go over there to that side. Okay.
Stephen Agnew. It's a question more than a point. If we redefine marriage, does the definition of family automatically change in the Constitution, or is that something that would need to be done separately?
Okay, I was planning to take a few, but that's a pretty substantial question. So perhaps, Jerry, are you the most likely?
For the reasons which I said this morning, I think if you change the nature of marriage, given that in the Constitution the family is founded on marriage, I think by definition you change the family. So there are inevitable knock-on effects, in my view. As to the categories of people who would be included in the concept of family under the Constitution.
Over there, if we take John.
Chairman, John Lardner. I believe that the rights have to be afforded to every child equally, but whether it requires a constitutional change and whether the legislators in their programme of government should be the ones to do it, I don't know. But I would throw and warn that caution, extreme caution, needs to be taken. And this is a matter, obviously, then for the entire population of Ireland to debate at length, carefully, that we undermine, or we may undermine, one of the main fundamental blocks of this state, of family, and of natural procreation. I believe the rights do need to be afforded, but whether it needs to come from changing the fundamental plan, the constitution of this country, or should it be done carefully through legislation under the programme of government, I'm not sure if the constitution needs to change at all. I actually looked at it and I thought to myself, there's nothing wrong with the constitution. The constitution is gender neutral. It happens to be that the high courts have taken a particular view on it. Legislation has followed suit. Perhaps it's with legislation that's wrong. Thank you.
Thank you, John. Now let's take another couple of comments before, and then go Aileen first, and then Deirdre. Yeah.
Thank you very much, Chair.
Again, name, please.
Aideen Hayden, Table 7. There was a reasonably strong feeling, I think it would be fair to say, at our table that there were perhaps two elements to this question. One was the right of a gay couple to marry, and the other were the follow-on consequences in relation to children. And in a sense, there was almost two issues. And it really pointed out to us that one of the things that perhaps is necessary is to revisit, as a matter of perhaps urgency, the definition of family in our Constitution. And that it wasn't just an issue in relation to gay couples, but an issue for couples who are not in a married relationship, full stop. So, you know, we felt that a lot of the debate that arose on the pro and anti side of the issue very much focused on the issue of gay couples as parents or in a relationship where children were involved, when in actual fact many gay couples are not involved in situations where children are involved at all and simply want a right to be a married couple. So to some extent, you know, maybe there is a case there for decoupling the two issues, addressing the rights of all parents in relation to children, and fundamentally the rights of children themselves. And that if the issue of what a family is, and if the issue of the rights of children, and in particular that the interests of the child should be the primary interest and fundamental to any decision that's made in relation to the child, whether it's relating to a biological parent, a biological mother, biological father. And we were very conscious of some of the emerging issues, particularly around assisted human reproduction, that are coming down the track. And that fundamentally the only way to deal with that is to deal with the fundamental rights of the child to be put first. And again, we were very persuaded by the human rights issues in relation to the right to marry.
Okay, thank you. I'll take Deirdre, and then we go back to the panel.
Hi, Deirdre Donaghy. I'm trying to reflect the views of the whole table as well. We had a very strong consensus, I think, in favour, and again, we saw it as a two-part issue. First of all, it's an equality issue for people in same-sex partnerships. They should have the same rights as everybody else. Again, the idea that anti-discrimination, it needs proactivity, it needs to be said in the Constitution because the case law seems to have interpreted it elsewhere. But it's a fundamental equality, that it's not trying to take something away from opposite sex marriages, it's just trying to give the same rights. The second part of it then is the follow-on, where it seems to, at present, we seem to disadvantage children of same-sex partnerships, and they don't have the legal rights, the legal protection. And then as people age, then same-sex parents possibly aren't able to be looked after by their children if it's not the biological parent. And one other thing we felt was that the presentations of the people in favour we thought were very persuasive, were very well made, well argued. We thought they were fair because they're saying we don't want to take away, we respect the rights, for religious freedom, that if religious institutions don't want to participate, then yes, they have the right not to participate. But when it came to the arguments from the other side, a lot of the terminology they used is almost the terminology that they should be using to argue for. They were talking about mutual respect and pardon me, what? Mutual respect and compassion and dignity, and these are surely words that should be used for accepting people and accepting everybody's rights and not to discriminate against them.
Okay, thank you. Okay, there's been 3 comments there, and a number, whoever wants. Tara, do you want to start, or
I think just
a microphone? Yeah.
just in relation to the surrogacy issue, I think, I'm sorry, I missed the lady's name. I'm so sorry. Aideen. I think Aideen is correct to draw attention specifically to surrogacy. We've seen a recent High Court decision in that area, and I think it's just so that we don't confuse ourselves in that surrogacy is not specific to same-sex relationships. This can arise in the context of opposite-sex relationship and has arisen in many circumstances in this country. And so I do think it is a valid point to say that parentage can arise in circumstances beyond the context of just today's debate. And that is something that needs to be considered also, even in the event that there wasn't a constitutional amendment. That's still an issue for lots of opposite-sex couples as well.
Any other comments from the panel about... Okay, could we move on to the next slide? Because again, I want to be fair in terms of presentation and so on. So it's up. Okay, so yourself.
Right, Alan Green. Sorry, Chair, just to interrupt before we move on to the next slide. I'd just like to address a claim, or I suppose a concern that's being raised by a number of individuals, as well as some of the advocacy groups, against the proposed change. And I'd like to ask the panel if there's any actual legal basis to their concerns. Would expanding the institution of marriage to include same-sex couples legally undermine the existing institution? And if so, how? Thank you.
Frankly, I don't think that's a legal question. I think judges occasionally say to juries, that's for you to decide. And I'm not being smart in that. I think what we're trying to do is explain that there are inevitable consequences to the changes we're talking about here. You've heard arguments in favour, you've heard arguments against, but it's not really a question of law of saying, would it do that? You have to make up your mind whether you think, having heard everything you say, it would have the kind of effects that's been suggested.
Jim, you don't, I mean, this may be way outside your territory. You don't want to make a comment on that, do you?
Well, not so much just on that, but on the point that Aideen made as well about the decoupling of the issues. The marriage issues and then the family and children's issues. And I suppose I'm just thinking about the rate at which diversity in forms of family life is growing. And I'm just wondering about what we would want our Constitution to do in terms of listing those types of changes, because I think this is going to be incredibly complex, because those forms are changing very fast. In some ways, we think about family, I think, in this country as some kind of form of co-residence. But that model of co-residence is already beginning to shift in certain places, where, and hence the term that I used in the start of my paper earlier, units of intimate belonging. It may be that people regard themselves as family to each other, people who do not reside together. you know. So I wonder, maybe this is a question back to the panel about what the lawyers would think about the challenge for transforming the Constitution into some type of redefinition of the family that requires a list of forms that are regarded now as family. And would we be into a situation where every time the form produced, you know, because it's like a multiplication element, every time the form produced another form, would we be changing the Constitution? So, that's a question.
Could I just say, well, my general view of constitutional change is very straightforward. The Constitution sets out the big picture. It's not suitable and it's not designed to deal with the detail. So exactly for all the reasons you've just said, I don't think it's a great idea to be trying to spell out in detail in the Constitution all sorts of different things, because no sooner did you do it then you might want to look at it again or whatever. Quite often what constitutions are meant to do is they set down the basic rules by which we govern our society. And then you spell out the detail of that by legislation. And quite often, the Constitution requires the state, or allows the state, depending on the wording, by its laws, to give effect to those general principles.
Okay. We're now going to go to this and, if you like, use that frame as the background for the next part of the discussion. I know Ronan did try earlier, so did you want to come in and then... Right. Yeah. Do you want to get a microphone, please?
Gormagat Cahirlig. Can I first of all say that unlike my colleague Aideen's table, I think I can report that we had a delightful diversity of views at this table. I think we were enjoying each other as well. It strikes me at this stage, and just having heard what Deirdre said, I think we should also, pay tribute to all our experts, but also the guest speakers. I think on both sides did manage to convey their deep respect for this process and their careful consideration of the issues, and I think all were sincere in their understanding of what a respectful culture will mean. I think that point should be made. Just in response to that, it strikes me that there are three questions, Chairman, that this may be a reasonable approach to help guide our thinking. Others may disagree. I think the first question is, there are so many complex issues here that our first question should be, have we enough in one weekend? Should we be looking at making a recommendation? I certainly know that at this table we only scratch the surface of various issues like assisted human reproduction, inter-country adoption, etc. So I think that's the first question, logically. Should we be moving towards a recommendation, or is it our sense that we really need more time on something as big as this? Second question is, if we do think then that we can safely move towards some kind of recommendation or recommendations, should we be looking at changing the Constitution, or a number of the issues that have been raised in relation to creating a culture of respect, anti-bullying, or the whole issue of guardianship rights? Some of these issues can be treated with by way of legislation. So a question will be, I think, or ought to be, and I think we've had a mirror of this in previous gatherings, could we achieve by legislation some of the things that we might wish to achieve, or does it require a constitutional change? And I think the third issue might be then that if we do decide to change the Constitution, in addition to or without legislation as well on other issues, if we do decide to change the Constitution, do we do so in a way that allows clauses to give, for example, respect to parents, families, organisations who might want to teach or espouse their view of marriage, be it same-sex marriage or marriage as it currently is defined? In other words, do we act to protect that freedom for people so as to prevent unintended consequences? Or another issue, do we change the Constitution in a way that allows legislators the freedom to deal with issues like assisted human reproduction, adoption, where they might want to nuance issues and provisions without attracting the censure, let's say, of the European Court of Human Rights? So in other words, do we go at changing the Constitution, but do so with clauses attached to protect certain outcomes that may not be considered desirable by some? Okay. And I hope that's in some way helpful, and if it's not, thank you for letting me get it off my chest.
Thank you. Richard, you wanted to come in?
Richard Codd. Mr. Chairman, just make one small point, really. It's the impression might be that those who were for the status quo were representing the churches per se. You know, all of them had church connections, and to say that there is I think a wider Christian perspective on this that wasn't really represented today. By choice perhaps, but just to say that there is a wider one than the one expressed today, and that while some of us who profess to be Christians find it difficult to value Scripture as well as a human rights issue, that we're grappling with that, and that there are many Christian members of the different churches who have come to the point of view that we can no longer stay with the status quo, and that there's a human rights issue here, and that a conscience issue, and that there's a body of Christians out there in favour of same-sex marriage.
Well, actually, that does give me the opportunity to say, because I did say I would say this, we did have one submission from a group called Changing Attitudes Ireland, and who were represented in the auditorium today, who made precisely that point, that, you know, there are, if you like, there is certainly members of the Christian tradition who have arrived at that view that Richard has just expressed, but just to say that there is actually a submission about it. Charlie.
Thanks, Mr. Chairman. Charlie Flanagan. I was really interested in the point my colleague makes behind me, and not surprised that he didn't get the type of answer he expected. And if I could perhaps provoke discussion on the same issue in another way. I'm struck since early morning about people speaking of the concept of traditional marriage and an attack or a fundamental change on tradition. And I think it was put on your previous slide that a tradition should perhaps be outweighed by equality. And I'm not sure the extent that we should be hamstrung by what we describe as tradition, because tradition implies no change. And yet over the years there has been huge change. Much of a fundamental nature. If we look at, if you like, the domination since the foundation of our state, the domination of marriage through, if you like, the prism of the Catholic ethos, and for the previous 100 years before independence, we had a similar type of influence of a huge nature on marriage through the Anglican Church. And then over the last 40 years, we had reforming pieces of legislation in our jurisdiction that did change fundamentally the concept of tradition. I'm thinking briefly of the Married Women Property Act, the Family Home Protection Act, the fact that we abolished such things as breach of promise to marry. We abolished the concept of conjugal rights. We introduced the criminal sanction for marital rape. And we did put marriage on a completely different footing without having a massive debate on changing of tradition. We changed our nullity laws. We changed our constitution to allow for divorce, having previously introduced the concept of judicial separation, heretofore unknown, but yet changing marriage as we knew it. And I merely make the point to reinforce the evolution of marriage in line with the answer that the European Court gave to Emer in the context of her questions or comments. Mm-hmm. So my point really is that perhaps we shouldn't be hamstrung by what we describe as tradition. Tradition implying no change when in effect we've had huge change, and that we should look more towards fairness and justice and equality rather than introducing a barrier of tradition, which I believe we can logically and compassionately dismantle in a way that doesn't damage society. Thank you.
Thank you very much, Charlie. Now, before going back to the audience, because we've had three substantial contributions there, I'd like to see, is there any, does the panel wish to comment on any aspect of those?
just one thing I wanted to say, because, and actually it was a question that I was asked by a number of tables, which was, can we deal with this by legislative change? Or can we deal with it by constitutional change? Or must we deal with it by constitutional change? And what I want to explain to you is at least what I think is the difference between the two. Obviously, some matters can be addressed by legislative change. But there's two things to say. The first is, when you're looking at all of this, go back to the concept of the Constitution as a set of rules, or basic rules, that the people say, this is how we want our society organised. If you feel that something is sufficiently important that that's part of that, well, then it probably should be in the Constitution. But the second thing about legislative change is what the legislature gives, the legislature can take away. And what I mean by that is there's a big difference, legally speaking, in having a constitutional obligation or a constitutional right backing you up and having a legislative right. Because obviously, if somebody decides, the legislature firstly mightn't give you whatever the right is, but equally another legislature might 10 years down the line or 20 years down the line say, hold on, no, actually, we're going to change that, we're going to take it away. The point about putting things in the Constitution, and I simply make the point is, once it's in the Constitution, the only people who can take it away are the people.
Okay. Sarah or Emer or Jim? No, nothing further to add. Okay. David, could we put up the last slide again, and then we'll go back to the audience. And I know you wanted to, I saw you first, and then if other people want to. Could we have the microphone here?
Thank you, Mr. Chairman. It appears to me...
name?
Connolly John. It appears to me as if there's an oxymoron going on. I'm not aware of the fact that you can have same-sex marriage. Marriage, by definition, in any book that I've ever looked it up on, was a union between a male and a female. And I don't think you can, I think it's an oxymoron. You can't have same-sex marriage. You can call it anything else you like, but you can't call it same-sex marriage, because you're saying same-sex, man-woman marriage, or words to that effect. I think we're dealing with an oxymoron here, and I think that we're confusing family with marriage, and I think that the last speaker today made a very good case in terms of treating the two things separately, giving every benefit one could to people who wanted to share by law, giving everything except the word marriage, and I would agree with that.
Okay.
Thank you.
Thank you.
Thanks very much, Chair. Darragh O'Brien, Table 2. I suppose I was struck today by, all the presentations I thought were very good and respectful and informative. But I think one of the things is that there's a crossover between civil and religious nearly in this, and that's why I think that because a lot of people would, when they see marriage or they use the phrase marriage, they automatically think of a religious ceremony. Most people do, and that's one of the things. So I think in the context of the debate, we should be looking at the debate is the same-sex civil marriage, because we are talking about a civil ceremony in that sense. And I was struck by some of the remarks with regard to unintended consequences. Like, this is a massive issue as to what other areas, such as adoption and that need to flow out from this should a referendum be passed. So there is a lot in it, and I think maybe a day and a half, more time, I believe, is needed to flesh out the other issues, not the issue itself. I think there's a broad agreement of fairness and equality that we should look towards same-sex civil marriage. But I was struck by one thing when we discussed education and education in our schools. And one of the best comments I heard earlier on today was from Sean Mullen, where he said we should be looking towards neither Nietzsche nor Newman. And in the context of this debate, we've got to actually look at, you know, what is fair to everyone, to respect people who don't agree with, for religious reasons, then they have well-held beliefs. And yet society moves on, and we have to recognise equality and fairness, and I believe that people should be treated equally and should have access to civil marriage should they wish to do so. But on the education side of things, and we did discuss this, and I don't know how maybe the panel of experts here, that should this be passed into law and you have religious faith-based schools who don't believe that, you know, that they believe that marriage is between a man and a woman, well, what effect does that have further on down the line with regard to, you know, teaching in those schools? People who decide to send their kids to be at Church of Ireland, Catholic, Jewish, Islamic faith schools. So there are other things that flow out of this, and it's not as simple as, well, I don't think anyone believed that it was simple, and it certainly isn't, because I thought of things today that I haven't thought about, you know, before as to what can flow out of it. But you know, I was struck by some of the examples about what's happened in the UK too. And I think some of them were unintended consequences, such as the closure of adoption agencies and that type of thing. So I think we've got to tread carefully, but I would stress that we should be talking about this in the context of same-sex civil marriage, in relation to even the ballot and that, because, you know, we've got to be clear. A lot of people will argue from the religious perspective that say, well, I don't want you, you know, infringing on my religious beliefs, but we're not talking about religious ceremonies here. I think we should be clearer about that.
Okay. Thank you, Dara. Comment over there, and then we'll go back to the panel. John.
It's John Lyons. I suppose just very, very briefly, what I really want to say, I suppose get something off my chest a bit like what Ronan said as well. Number one, you know, I just want to say, first of all, I feel exceptionally privileged to be here today. It's one of the reasons why I asked to be a member of the Constitutional Convention, because this is possibly the most important issue that I will ever deal with in my political career, I think. And it's something that is personalised to me too, as somebody who is gay. And I suppose what I really want to say at the end of the day is that Dara alluded to it, that this is a civil issue. This is an issue about asking the state to treat same-sex couples in the same way it treats opposite-sex couples when it comes to marriage. That's what we're asked today. It's around that particular issue. I mean, I think there should be respect for what, you know, some of the religious organisations here said today, and I'm glad that, Tom, that you did mention that, and Richard mentioned as well, there are other groups within, you know, religious communities who are totally in favour of marrying gay and lesbian couples. Solemnising, I just couldn't get it out. Anyway, but can I just finish up on this really as such? You know, we can call it what we want, and this is my own personal view. We can call it what we want, but refusing to allow same-sex couples to marry through the eyes of the state is discrimination. The blood that flows through my veins is the same as the blood that flows through anybody else's veins. And to treat me differently because of who I sleep with at the end of the day, or who I choose to say who I love, is a form of discrimination. And a state that allows that to happen is not a state that I think I would like to bring people into or be proud of. And we here today, and I have to say it, and I will really finish up this, Tom, here. I was sitting here thinking, you know, I'm going to put some of the memories of the experiences I had here today into somewhere up here and remember them, because they were really fantastic. They were life-changing experiences. Hearing Conor and Paula talking there, I mean, some of us here were literally, you know, holding the tears in, you know, with the moving things that they said. And I just really think, you know, remember the experience you have today. It's something that we're not going to have all the times in our lives. It's a very special and privileged moment that we all have here to be discussing an issue that can really progress our society, I believe, to a society that we can be proud of and treats everybody equally. And this is one of the remaining institutions within our society that allows blatant discrimination to happen to people based on who they sleep with. I'll finish on that. Thanks very much, Tom.
Thank you, John. Now, I know that some of those last few comments are not necessarily bearing on the legal, but if there were any comments that any of you want to make on any of those comments, do you want to, or not?
could I just deal again, because I'm kind of here to deal with the constitutional end of things and changing the constitution and what the effects of it are and how it might be done. One of the good things about changing the constitution is if you look at constitutional changes, you can decide what you want to put into it. And the issues of faith schools, freedom of belief, education, all of that, when a proposal is being put, you can choose to put in something that specifically addresses that if you want. You can put in a sentence that sort of deals with that territory. Equally, you can give the legislature power to deal with it by in the Constitution. So when the people vote on something and when the government and the Oireachtas puts a proposal, it can be a proposal which is tailored, if I might put it that way, to protect things that need to be protected. Now, obviously, what comes out at the end of the day is a matter for the government and for the Oireachtas at the time. But you can build in, if I might put it that way, protections into what you're doing. And obviously, one of the things that might come out of the discussions today is if that ever came about or you're ever in that situation, it would be a very sophisticated degree of thought have to be put into how those protections might be organised.
Yeah, I mean, obviously that's a very fair comment. Susan?
Thanks, Chair. Susan O'Keefe. I suppose I just wanted to add, Gerard, to maybe what you said about the Constitution being a set of rules in the bigger picture. I suppose for me the Constitution is really a sort of statement of who we are as a society and what we value. And for me, I would want to be living in a country where the Constitution was a statement of value of everybody equally. And that in that case, for me, the only place for this to be altered is in the Constitution, and that any other form of alteration of the rules or regulations in law to allow perhaps for some equality is just falls short. I think I described it here at this table as a form of subtle discrimination, that if you say, well, civil partnership is enough, for me it's not. It has to be in the Constitution, because the Constitution is ultimately who we are and what we value as a people.
Thank you, Susan. I'm going to take maybe one more comment, because I want to make sure that we have the final panel, we have time to get them established, because they're you know, it's a short enough time with 5 very interesting people. Chris, you have the last word for the moment.
No pressure.
Yeah.
Turn around and face the whole crowd. It's kind of scary up the top. Hi everybody, my name is Chris Lyons. I just wanted to say that during the day and during the discussions, a lot of words like issues and concerns and consequences were thrown around. And it kind of got me a bit upset, because it's not only an opportunity to discuss about what could go wrong, but it's absolutely an opportunity to talk about what will go right. Because when I feel the lack of rights in my own life, there's only opportunities for things to get better. And there's only opportunities for people in this room to make a decision to put something in our Constitution to protect young people who are gay and who are lesbians, to expand their right set, to say to the international community, Ireland values the fact that there's a diversity of familial life, there's a diversity of sexual life, and that Ireland values and respects that. It's going to say so much to the people. Young people are leaving the country in droves, and I mean, I don't want to have to be another young gay person who has to leave to have a marriage recognised in a country that isn't mine. As a young patriot, I don't want it for Ireland. But equally, I don't want it for you guys either, to sit here and talk about worries and fears for religious groups and for social groups. It's not something that has to be a negative. It can absolutely be something that's positive. It's positive in my own life, and I think that it will be a positive for the diversification of people in Ireland. And I think that maybe, as you think about it over the evening, if you could think of it in a positive light, instead of going, oh no, what will happen if, and what will happen to the children, and what will happen, God forbid that a gay couple will want to look after a child that doesn't have a home. That'll be, you know, I mean, that's a good thing. It doesn't have to be that they'll be lost and lonely and won't have a mother. It could be, well, they'll have a family that they wouldn't have had otherwise. So I just want you to maybe reframe the way you're thinking. You know, it doesn't have to be a negative, and it will absolutely be a positive. to my mind anyway, at least.
Okay.
Is that okay?
Thank you. Thank you, Chris. Chance for any last words from Jim? Would you like maybe to have the last word?
Well, not the last word. Just want to say that I connect very strongly with what you're saying, with what Charlie Flanagan was saying, that in fact, really, thinking positively about the change possibilities and the possibilities that change and open up is so important. Charlie, as I heard you, you were talking about the revitalisation of the tradition of marriage, you know, about it, unless it's a tradition, unless we wanted to make a dead tradition, which is going nowhere, we have to think about revitalisation. And these are ways of revitalising marriage. And of course, one of the things that's excited me about listening into this conversation is that I think there's a real interest in marriage in this country, and there's a real interest in celebrating it, you know? And we celebrate lots of other things, but traditionally, you know, in society, in our society, we're very good on celebrating mothers and fathers, and we have birthdays and Mother's Days and Father's Days. Is there any public day that celebrates marriage? I don't think there is, do you know? So we don't do that. Maybe we might do that in the future.
But we probably don't have to write it into the Constitution.
We will certainly not write it in the Constitution.
Okay, I just want to say, I just want to say thank you for this really, really vibrant engagement in this last session today. I think it's been really positive, and we conclude it now.